Nice Radio Kalaloo presents Just Another Look. Just Another Look is an innovative, exciting, albeit decidedly provocative and yes, certainly controversial, socio-political analysis of issues of a local, regional, and international nature. Just Another Look is heard only on Nice Radio, first aired on Saturdays at 6 p.m., with repeat broadcasts on Sundays at 9 p.m. You can catch us on the World Wide Web, www.niceradio.info. You can check out our Just Another Look blog, www.justanotherlook.com. And of course, you can find us on YouTube. I am, of course, Keith Joseph. Today is Saturday. It is the 12th day of January 2019. Welcome to another edition of your favorite program, Just Another Look. As promised, dear friends, in our last program, first aired on Saturday, the 5th of January 2019. Today's program focuses in the main on the matter of the Public Service Union and the Public Service Commission in the nation's court. Perhaps there's no better way to start than to return to the Gonzalez dictum. The worst type of slave is he who presumes to know what the master is thinking, and who, without ever being given instructions by the master so to do, goes ahead and does what he believes the master would have done in any particular situation. You know, we've heard that more or less, not exactly the same words perhaps, but we've heard that kind of dictum repeated across this nation on several occasions. And one wonders to what extent it is a reflection of what obtains in St. Vincent and the Grenadines today. We ask ourselves, even as we go through this particular issue, we ask ourselves whether people believe, rightly or wrongly, that the positions into which they have been placed commits them to acting in a particular way, such that fair play and justice, meritocratic principles, etc., may not necessarily be the best and most important issues impacting their actions, but that these may The most important factors may well be how they perceive they ought to act based on their political affiliation. And it's important because I'm saying maybe we all need to ask ourselves when we examine behavior in St. Vincent and the Grenadines over the last several years as to whether we can determine what have been the major considerations impacting these behaviors. It is important for us to have an understanding because over the last several years, Just Another Look has been insistent that we have become a nation divided along political party lines. And you see it just about everywhere. Some people have gone so far as to paint their vehicles in the colors of the party they support. Some have committed to wearing clothes reflecting the colors of the parties they support. And there have been accusations thrown left and right in this country about the quote-unquote new dispensation, which some may well be interpreting to mean that it is quote-unquote our time now because our party is in charge. Never before, not since the days of conquest and colonization, has St. Vincent and the Grenadines ever been as divided as it is today. Never before, not since the period of conquest and colonization, has this country ever been as divided as it is today. And what is perhaps most heart-rending is the fact that the political leadership appears somewhat nonchalant about the whole reality. And one would very well come away with a feeling that the political leadership of the country does nothing wrong. That they're almost infallible. It is always somebody else. as some of the people in this particular issue today would come to realize. It's always somebody else. It is never really the fault of the political leadership. They do nothing wrong. There's no reason for them to apologize for anything. It's always somebody else that has fallen short. So this week's program really addresses the ruling of Justice Esco Henry. Justice Esco Henry in the matter of the Public Service Commission, or the Public Service Union and the Public Service Commission of St. Vincent and the Grenadines. And actually, reading the judge's ruling gives us a frightening reality of how things are done in St. Vincent and the Grenadines today. And perhaps we should say that anyone reading the judge's ruling would come away with a very bitter taste. A very bitter taste about some of the things that have happened in the public service. And certainly in respect of these 5 officers. The Prime Minister of this country, himself a lawyer of several years, can only be embarrassed, by the seeming indictment of the ruling relative to persons assigned with authority at different levels of the government service, starting with the leadership and membership of the Public Service Commission itself. The reality of what transpired in the courts, the reality of what led to Justice Henry's ruling, may well have forced the comrade, the Prime Minister, jolt him back to the harsh reality of just how much governance issues are a bother in this country under his leadership. And to distance himself from the officials who have been identified in the matter. And we say governance issues placing governance issues under his watch, because ultimately the Prime Minister and his cabinet can say all sorts of things, but at the end of the day they are responsible during their term in office, because they constitute the executive arm of government during their tenure. And so what goes afoul of the expected norms in the way governance is practiced in the country during their tenure has to be placed squarely on their heads and their shoulders. They cannot escape it. They may try political demagoguery to pass it on to somebody else. And so we are concerned about some of the comments made by the Prime Minister since the ruling. But they have a collective responsibility as cabinet. We will address this and other matters in what must be a turning point in the practice of industrial relations and the broader jurisprudence in St. Vincent and the Grenadines. And reason enough as to why we must all hang our heads in shame and call for the resignation of several of the officials involved. You see, when you look at St. Vincent and the Grenadines today, the law and you is of little value to Vincentians who are on the receiving end of matters that leave many of us decidedly at the mercy of those in authority at the governmental level. You see, they have to live with themselves. They have to live with themselves. And Vincentians may well be waking up to a reality today that suggests theirs is not the plight of the likes of a Pierre Campbell of the Law New fame, or a Blazer Williams of the Public Service Commission fame. We need to remember that in the lead up to the general elections of 2001, the opposition Unity Labour Party, and Gonzalez in particular, kept insisting that the then Prime Minister Arnim Eustace was the one who was beating up on the public servants. That became part of the electioneering that took place. And used it as an indictment of the New Democratic Party. And we are in interesting times now. Because if you recall, in 2000, April, May, what eventually emerged as street protests began with the teachers' union demanding a 30% increase from the New Democratic Party government at the time. That's how it started. And the host of Just Another Look conducted an interview on the streets in front of the Ministry of Education with then opposition leader Ralph Gonzalez. And his response, in part, was that, you know, Keith, the demand for 30% is not exactly outlandish. Because when one takes into consideration the extent of the greed and graft and corruption that is taking place in this country, 30% is not unreasonable. That was stated live on Nice Radio from the interview on the street. And the union, emboldened by such statements and of course other issues that were heaped on it, moved on in their challenge of the government, and of course the rest is history. At the start of 2019, the Teachers Union and the Public Service Union have come together to announce that on the 29th of January, they will engage in a joint protest. And as many of you would have read in the weekend newspapers. It has been a very long time since the teachers union has had the benefit of negotiating a collective agreement. So 14 of the nearly 18 years that the Unity Labour Party has been in office, the teachers union has not been involved, in any direct negotiations relative to agreeing to getting at a collective agreement with the government. Now, if that is true, and there's no reason to doubt it, what does that tell you about governance, ULP style? And it is interesting that there has been a juxtaposition this past week of the matter of Justice Esco Henry's ruling on the Public Service Union's case on behalf of 5 of its members. The response of the Prime Minister of this country. The decision by the Public Service Union and the Teachers Union to have a joint protest on the 29th of January. And the Prime Minister's decision to have a meeting, as the Teachers Union President Wendy Bino stated, we've been invited at short notice to meet. And then, of course, they went to the cabinet room, but they never really got started because they were told something about no cell phones, etc. But as you have recognized, those of you who are on the social media, there's a picture circulating where some are asking, well, if no cell phones were supposed to be in the room, what these pictures, how did this picture emerge? More questions, of course, than answers. But after listening to the ruling of Justice Esco Henry, one wonders who is exactly beating up on public servants. The crux of the matter is that the Public Service Commission is a creature of government. And while many boast of its independence from political machinations, others challenge this based on the actual mode of operation of the institution. Let us now review the ruling as best we could, because this is particularly important. The case SVG HCV 2016/0219 in the matter of Chapter 10 of the St. Vincent and the Grenadines Constitution Order of the Laws of St. Vincent and the Grenadines, Revised Edition 2009, and in the matter of Part 2 of the Public Service Commission Regulations to Cap 10, the St. Vincent and the Grenadines Constitution Order of the Laws of St. Vincent and the Grenadines, Revised Edition 2009, between the Public Service Union of Mackey's Hill, the claimant, and Public Service Commission defendant. Counsel for the claimant, Public Service Union, lawyer Joseph Dells. For the defendant, which is Public Service Commission, the Attorney General John D. Martin, Dwayne Daniel, and Shernell Hathaway. The dates: November 14th and 21st, 2017, and 2018, February 2nd, March 8th, March 13th, June 26th, and December 19th. Justice Esco Henry, in her judgment, identified the issues in the case. One, whether the Public Service Commission has failed to comply with the procedures outlined in the Public Service Commission Regulations 15, 19, and 20 governing promotion. Two, whether the Public Service Commission has failed to observe principles of fairness, transparency, and objectivity in exercising its functions under Regulation 19. And the third issue, to what relief, if any, is the Public Service Union entitled? Those are the three issues. It all seems to have begun with the Public Service Union becoming frustrated with the Public Service Commission's apparent failure to adequately address the concerns raised in complaints by some of its members. By some of its members. And the members in this particular instance: Elroy Boucher, Agnes Noellen, Joel Poyer, Conroy Daniel, and K. Joe Peters. And so the Public Service Union as the body to which these individuals are members, the collective bargaining agent, the legitimate collective bargaining agent on behalf of these people, decided to go to the courts because they felt that that is where they were going to have redress. But the minute that the Public Service Union decided that it was going to go to the court, the Public Service Commission challenged the jurisdiction of the nation's courts to become involved in this matter. They said it had no jurisdiction. And the Public Service Commission's basis for that claim was that in matters relating to the performance of public officers, they have to seek redress at the Public Service Commission, these individual members of the public service. But Dells did an excellent job in articulating the position that these were not individual members coming to the courts. It was their bargaining agent, the Incorporated Public Service Union, that was acting as the body that was bringing the matter before the nation's courts. And so the matter was addressed from that context. And the judge, Justice Esco Henry, ruled that the court had the jurisdiction. So that was the first blow to the Public Service Commission. And everybody in the Public Service Union And every public servant ought to be grateful that that was the ruling. Because what eventually transpired gave us a very good insight into how the Public Service Commission itself functions and how some senior members in our public service have been operating. Can you imagine what would have happened if at that point the judge had ruled otherwise and the matter was left only with the public service? When you hear some of what has emerged, you would cringe at that possibility. In her comments, in her judgment, Justice Henry said in part, and we quote, "The Public Service Commission's failure to respond to the Public Service Union signaled its disinterest in seeking to address the complaints made on behalf of the public officers. By doing so, the Public Service Commission effectively closed the door to the body of public officers obtaining relief in an expedient, efficient, and effective manner. The 5 named public officers were therefore entitled to conclude that they had invoked the referenced civil service orders or provisions, albeit in a collective and not expressly prescribed manner." End of quote. As the judge's ruling. The Public Service Commission effectively closed the door to the body of public officers obtaining relief in an expedient, efficient, and effective manner. Understand that? Justice Henry also stated, and we quote, "Decisions by the courts and tribunals have emphasized the importance of not sacrificing substance and justice on the altar of procedure." Major statement. And she goes on, "Administrative bodies charged with regulatory and public administration functions would be well advised to adopt this approach in carrying out their functions. In my opinion, the Public Service Commission's apparent insistence on form over substance runs afoul of the overarching ideal of attainment of just outcomes." End of quote. You see, that's why in the last meeting, dear friends, in the last edition of Just Another Look, we indicated we were going to address this matter in this particular edition. And we asked people, read the judgment. Read it carefully. Because it has implications for an understanding of governance in St. Vincent and the Grenadines today. You will come away with an understanding of how things are done. And it will respond to your question, how is justice served in this country? You see, good sense and a desire for fairness seems to suggest that always, in such instances, substance should override form. All too often, we have a tendency to be more concerned about the form while ignoring the implications of a failure to have substance given the priority that it deserves. But there are some important, the entire document is very important. But for this program, we will take excerpts that we deem particularly important. Justice Henry noted in her judgment, and we quote, "During cross-examination, the chairman of the Public Service Commission," which we all know is Cecil Blazer Williams, the chairman of the Public Service Commission acknowledged that public officers may be promoted across departments within the civil service. He accepted that the Public Service Commission must therefore know which officers are the most senior within the service if the promotion process is to work. He accepted that the Public Service Commission did not produce the seniority lists in accordance with Regulation 19 and did not disclose them as ordered by the court because she asked for it. He accepted, Mr. Williams acknowledged that he understood the duty of disclosure. He accepted that he's a lawyer of 20 years call and understands how disclosure works. End of quote. Are we understanding what happened here? In her judgment, she is saying to us that the head of the Public Service Commission, Blazer Williams, a lawyer for more than 20 years or so, and who has been head of the Public Service Commission for several years, since 2001 or thereabouts, several years, says he understands what disclosure. He understood the duty of disclosure. He understands how disclosure works. Yet he accepted that the organization he heads, the Public Service Commission, did not produce the seniority list in accordance with Regulation 19 and did not disclose them as ordered by the court. He did not follow a court order. His organization did not. So this particular paragraph speaks volumes for us on the outside relative to what has been occurring here. So if you know that according to your own regulations, there ought to be seniority lists across the board, you've been asked to produce said seniority lists, and you couldn't produce them, even though the court ordered you so to do. What does that tell you, dear friends? What does that tell you? It's important for us to know, that we have been under what they call an education revolution since the ULP came to office in 2001, Is this what we get under an education revolution? Is this what we get? But you see, there is much more that we learn from the document, from the judgment. We quote another section. By his own admission, Mr. Williams has accepted that the Public Service Commission failed to comply with the court's order for disclosure of the seniority lists. End of quote. Let's read that again. By his own admission, Mr. Williams has accepted that the Public Service Commission failed to comply with the court's order for disclosure of the seniority lists. She goes on, the court, therefore, did not have before it material which was relevant to conducting a comprehensive review of all relevant data. In this regard, the Public Service Commission offered no explanation to justify its default. It appears there is none. End of quote. This is the Public Service Commission. This is the body that handles appointments, promotions, discipline, etc. This is the body. But it has failed to comply with a court order. You see, it must be a most embarrassing thing that the Public Service Commission, chaired by a lawyer of some 20 years' experience, would have found itself being so humiliated in the nation's courts. One would have expected, therefore, that once this kind of indictment comes out, everybody would resign. Nobody should ask you to do that. There should be an early recognition that that is the only way out, because you have defied a court order asking you to bring information that is relevant for the court to be able to conduct a comprehensive review of all relevant data. Public servants may well have a right to be scared that this is the body that bears responsibility in this country, in the government, for appointments, promotions, discipline, etc. in the public service. Indeed, the comments of Justice Henry takes us back to the Aother debacle and compels us to an annoying conclusion regarding the location of fair play and justice in such circumstances in the public service in St. Vincent and the Grenadines. That's what it takes us back to. Aother had to take his resources and fight this battle. And so what we're hearing here now should not surprise us, given what happened in the Aother case. But you see, the business of it's our time now does not allow for a genuine national discourse on the mode of operation of our major institutions of government and governance. We prefer to trivialize things. And in some instances, our politicians are more concerned about profiling than about substance. And they know themselves. They know themselves. Let us be mindful of Justice Henry pointing out and we quote, by order made on 21st February 2017, the parties were directed to make standard disclosure on or before 31st March 2017. it cannot go unremarked that neither the Public Service Commission, through its legal practitioners, nor its witnesses, or its chairman, Cecil Blazer Williams, attempted to present to the court the mandated seniority lists. End of quote. You understand that? You understand the nature of this statement in her judgment? That in February, she gave them a deadline by which to submit the seniority list. And she says it cannot go unremarked that neither the Public Service Commission, through its legal practitioners, and we told you who they were, nor its witnesses, or its chairman, who she named, Mr. Cecil Blazer Williams, attempted to present to the court the mandated seniority list. Now, when a judge puts that in a judgment, it's a very serious matter. An extremely, extremely, extremely serious matter. You know, hear this, and we quote, by affidavit filed on 13th October 2017, Mr. Kezran Walters deposed that attempts were made to file standard disclosures ordered. Right, that's what the seniority list. He stated that the chief personnel officer went on leave soon after. And it was discovered that the seniority list was not as easily obtained as both the chairman and the Honorable Attorney General thought, because the file was at the Treasury Department. At the trial, Mr. Cecil Blazer Williams testified that he did not know if the file was sent to the Treasury Department as alleged by Mr. Walters. End of quote. So this is part of the confusion. The judge is saying that Mr. Walters says they were trying to get this thing, get the seniority list as required, as ordered. But the person in charge, the chief personnel officer at the Service Commission, went on leave. He's saying that finding the information was not so easy as chairman of Public Service Commission and the Attorney General thought. So you understand what is happening at our Public Service Commission. In the seniority list that they claim to be using for promotions that they can't find, you know. You have an understanding of this? So if indeed, as we mentioned earlier, that Blazer was saying, yes, they're supposed to use, they use seniority lists, and they can't find it when ordered so to do by the court. Seniority lists across the public service. Then what were they using for promotions since they got into office? What were they using? If they didn't have the seniority list, if they couldn't find it when ordered so to do by the court, one is left to assume that they probably couldn't find it for a very long time, and then what? You see, and then he's saying the file was at the Treasury Department. But Blazer testified. He's head of the organization. And he testified he did not know if the file was sent to the Treasury Department, as Mr. Walters said. But did he know where the file was? He did not know if it was sent to the Treasury Department. But he also did not know where the files were, from all appearances. So it is interesting to note that Justice Henry, in assessing the presentations by Williams and Walters, made the following comment, quote, "In the face of the foregoing testimony from Mr. Williams and Mr. Walters, it is reasonable to infer that the Public Service Commission's failure to disclose the seniority lists specified by Regulations 18 and 19 was deliberate and intentional, and was also activated by an improper motive." End of quote. Voila. Voila. Understand, people, why it is necessary to go into these details. This is judge in her judgment stating, and we quote, "In the face of the foregoing testimony from Mr. Williams," who is Cecil Blazer Williams, and Mr. Kezron Walters, who said he went looking for the thing and it wasn't so easy to find the seniority list, it is reasonable to infer that the Public Service Commission's failure to disclose the seniority list specified by Regulations 18 and 19 was deliberate and intentional, and was also activated by an improper motive. End of quote. Understand what this means, dear friends, and why the Public Service Union has to feel emboldened, and why every public servant that feels justly that they have been overlooked in respect of promotion and advancement within the system should now be moving towards their union to take their matters to court. They must be emboldened by this reality. Justice Henry went on to say, and we quote, "The failure," meaning the failure to provide the seniority list, "invites the making of adverse inferences. Essentially, the non-disclosure and non-production of the statutorily mandated seniority lists belies Mr. Williams' testimony that seniority lists are maintained by the switching the context of this case. It is also noted that the Public Service Commission disclosure of 4 documents that it described respectively as seniority lists in respect of the Customs and Excise Services, Policy Development, and Admin National Mobilization, Forestry Services, and Prison. They contain the names of officers by grade. The documents indicated the post of each officer and the respective dates of appointment. None of the witnesses identified or described any alternative mechanism or records which were maintained by the Public Service Commission or its satellites, which were consulted during promotions hearings and determinations over the reference periods. it follows that when the Public Service Commission considered promotions to posts for which the named officers were eligible, it could not have been and was not adequately apprised of the names of all eligible officers across all departments and ministries within the civil service. The failure runs afoul of the stipulation in Regulation 20 and Regulation 19, 1, 2, and A, 1 and 2A and 3B. In this regard, the Public Service Commission would have been unable to take into account the position of an officer's name on the seniority list and his seniority relative to other eligible officers. End of word. End of word. In other words, dear friend, it was an open sesame. There could be no guarantee of the kind of fairness, transparency, and objectivity that should characterize the operations of the Public Service